And good morning, everyone. I'm Kira Phillips. We're coming on the air because the Supreme Court has just released a major decision involving President Trump's tariff policies and whether the president exceeded his authority with sweeping reciprocal tariffs on other nations, the centerpiece of his economic agenda. Let's get right to ABC's senior Washington correspondent, Devin Dwyer, who covers the Supreme Court for us. Devin, your thoughts?
Kira, this is one of the most significant decisions on presidential power in decades. The Supreme Court, just moments ago, in a 6-3 decision authored by Chief Justice John Roberts, invalidated most of President Trump's tariffs. 70% of the tariffs he's imposed so far in his second term here have been under the law known as the International Emergency Economic Powers Act. It was written in 1977. He claimed it gave him unlimited power to tariff any country at any level for as long as he wants. And Roberts said the law simply does not give him that authority.
Hey guys, welcome. Adam is here. So what just happened, guys? Trump spent years believing the Supreme Court was his appointees, his fortress, his insurance policy. He burned bridges, endured scandals, and sold his base on every bitter pill to reshape that court in his image. Then, on an ordinary day that will be etched into history, the justices he personally placed on that bench swung the doors open from the inside and told him in the most formal language American law possesses, "You went too far, you don't have the power you think you have, and the blank check you've been writing against emergency authority is fraudulent."
This is one of the most significant Supreme Court losses for a U.S. president in modern history. I mean, the justices invalidating a key part of President Trump's economic policy agenda. And this afternoon, like you said, he blasted the court and said the fight for tariffs wasn't over.
I'm ashamed of certain members of the court.
An angry President Trump lashed out at the justices, turning his ire on three of the court's conservatives, Neil Gorsuch and Amy Coney Barrett, justices he put on the court, and Chief Justice John Roberts, who wrote the opinion.
They're very unpatriotic and disloyal to our Constitution.
The three joined with the court's three liberal justices to rule that the federal emergency trade law that gives presidents power to regulate imports did not authorize President Trump to impose tariffs. Said the Chief Justice, had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly.
Trump didn't lose the Supreme Court. He discovered he never had it. The ruling came down with the force of a guillotine, 6-3. That number matters more than almost anything else in this entire saga. Chief Justice John Roberts, the institutionalist who has spent a career trying to keep the court out of the political mud, authored the majority opinion. But he did not stand alone.
We begin with the decision with major implications for the economy and your money. The Supreme Court dealing with a major blow to President Trump's economic policy, striking down his sweeping use of tariffs.
It was a 6-3 ruling today, with two justices appointed by President Trump himself siding with the majority. The president railed against the decision today, calling it deeply disappointing and saying he was absolutely ashamed of the justices who voted against his policy.
And the president has already announced alternative plans to keep his tariff policy in place. But what about all the money that was already paid?
Flanking him on either side of the ideological divide were the three liberal justices, yes. But more importantly, they were joined by two figures who represent the crown jewels of the Trump judicial legacy: Neil Gorsuch, Amy Coney Barrett, the justices whose confirmations were celebrated as the ultimate vindication of the Trump project. And together, this coalition of six delivered a verdict that legal correspondents immediately flagged as a rare and unmistakable public rebuke.
The Supreme Court's ruling on tariffs is deeply disappointing.
President Trump sharply criticized the Supreme Court justices who struck down his sweeping tariff policy. That includes two justices he nominated during his first term, Gorsuch and Barrett.
I'm ashamed of certain members of the court, absolutely ashamed.
In a 6-3 decision, the High Court ruled the president does not have the authority to impose tariffs under a 1977 emergency powers law that he used to wage taxes on nearly all U.S. global trading partners.
The language was surgical. The president, the court declared, cannot treat emergency and trade statutes as if they were a bottomless well of authority. His sweeping, unilateral attempt to rewrite the architecture of global trade by fiat had blasted clean through the boundaries of what Congress ever intended to delegate. The constitutional theory that served as the engine room for his entire second-term governing philosophy, the belief that declaring an emergency magically transfers legislative power from Capitol Hill to the Oval Office, was not just flawed, it was legally erroneous. Wrong on the merits, wrong in a 6-3 opinion, wrong according to the very people he had personally selected and fought tooth and nail to confirm, wrong in ink that will never dry. And within the span of time it takes to pour a cup of coffee, before the legal scholars in Washington had even finished downloading the PDF, the reaction came. Not from a spokesperson, not from a carefully crafted press release vetted by a team of lawyers. It came directly from the source, raw and uncut, on live television. He was raging. The word betrayal hung in the air like smoke from a chemical fire. He accused the court of sabotage. He insisted the ruling had failed miserably and had effectively crippled his ability to govern the nation, and then he uttered the phrase that exposed the entire architecture of his misunderstanding. He called them my own justices. Think about the possessive weight of those 3 words. My own. As if the lifelong tenure on the highest bench in the land is merely an extension of a real estate portfolio. As if the black robe is just another uniform in the Trump organization. That phrase revealed more about how he perceives the relationship between the executive and the judiciary than any legal textbook or constitutional law lecture ever could. He spent years telling anyone who would listen that the court was his legacy, that the seats were the prize for the pain. And now, those very justices had just applied the principles of the Constitution to his actions and found him wanting. The man who built his entire political persona on the myth of being unstoppable, the man who convinced millions that emergency powers were a superpower only he was brave enough to wield, just had that superpower stripped away in open court. And the meltdown we witnessed was not just anger, it was the sound of a worldview shattering in real time. Every foreign ministry, every hedge fund manager, every Republican strategist mapping out the midterm minefield, and every American citizen saw it happen without a filter. The reign of, I can do whatever I want, didn't end with a bang of impeachment or a whimper of resignation. It ended with a constitutional line drawn in permanent ink by the court he built. Now, let's pull the camera back and give you the full, unvarnished truth of what this ruling actually erected in the path of this presidency. The calendar still has pages left to turn. The term doesn't officially expire until the clock runs out. But the operating system, the software that was running the machinery of the second term, that has been declared obsolete and unsafe by the highest technical authority in the land. The specific constitutional theory that formed the bedrock of everything, the idea that a president holds essentially limitless authority over economic and national security matters simply by declaring an emergency, has been ruled unconstitutional. And it was ruled unconstitutional by a supermajority that included the very people Trump placed on the court to prevent exactly this kind of outcome. The blank check has been ripped to shreds. The governance strategy that relied on bypassing a sluggish Congress, on pressuring foreign governments through unilateral economic thunderbolts, on reshaping global trade through executive decree rather than legislative negotiation, all of it has just collided with a solid wall of constitutional granite. Legal experts were swift and unanimous in their parsing of the fallout. This doesn't just blow up one tariff scheme. This rewires the entire circuit board for the remaining years of this administration. It compels the White House to go, hat in hand, to the very Congress it has spent years mocking and marginalizing, to ask for the authorities it had assumed were already in its pocket. It ensures that every future claim of vast emergency power will be met with the major questions doctrine challenge that just eviscerated this tariff plan. For a president whose brand identity is synonymous with the image of unyielding, uncheckable power, the guy who promised he alone could fix it and that the normal rules didn't apply to him, this united stand from the Supreme Court is more than a legal defeat. It is the moment the factual constitutional reality of limited government crashed head-on into the political fairy tale of unlimited presidential power. And that live television meltdown, that was the audio of the wreckage. Here is the specific reason why the phrase "Stand United" is not just a catchy headline, but a seismic legal event. Look at the roster of the majority. This was not a 5-4 squeaker driven by the court's progressive wing plus a couple of squishy moderates. If it had been, the political spin would have been easy. The base would have heard activist judges and moved on. But this was 6-3. And the two votes that tipped the scales from a simple majority to a commanding, undeniable supermajority belonged to Neil Gorsuch and Amy Coney Barrett. These are not liberal plants. These are the conservative movement's own flesh and blood. Gorsuch, whose seat was held open in a brutal act of political warfare to deny the previous administration a pick, a victory Trump hailed as a generational shift in the judiciary. Barrett, whose lightning-fast confirmation in the twilight of the first term was sold to the American people as the final brick in the wall of a conservative legal fortress. Both of them sat on that bench. Both of them reviewed the sweeping claims of tariff and emergency authority. Both of them weighed those claims against the Constitution's explicit assignment of taxing and trade power to the legislative branch. And both of them looked at the president's argument and said, in essence, no. The law does not say that. Congress did not write that check. That is the death knell for the partisan witch hunt narrative. This is conservative jurisprudence eating its own cooking. It is the legal principles that organizations like the Federalist Society have spent decades cultivating being applied consistently to a president who believed he could simply declare his way out of the constitutional framework. The signal this sends cascading down through the marble halls of every federal courthouse in America is unmistakable. If the Supreme Court, with its conservative supermajority, is willing to apply the major questions doctrine to strike down this president's power grab, then every district court judge and every appellate panel now has the brightest possible green light to scrutinize every other emergency power claim with the same rigorous, unforgiving lens. The Stand United is real because the conservatives stood with the Constitution, not with the man who appointed them. And that independence is the very oxygen of a functioning republic. The message to the administration, to foreign capitals, and to the markets is crystal clear. The constitutional cage exists, and the keepers of the keys, even the ones you personally hired, will not unlock it for you. And then, of course, there is the meltdown itself. Because the content of that live response is a primary source document of staggering political and psychological significance. It wasn't a strategic pivot. It was a window into the soul of a political operation that had mistaken the judiciary for a subsidiary. The specific phrase, "my own justices," is the Rosetta Stone for understanding the entire crisis. It confirms a worldview where the confirmation of a judge creates a personal IOU. Under this theory, a seat on the Supreme Court isn't a public trust, it's a patronage job. The justice owes a debt of loyalty to the patron who secured the position. A favorable ruling is simply the repayment of that debt. An unfavorable ruling, a ruling that applies neutral constitutional principles to limit the power of the patron, is not just a legal error, it is an act of personal treachery. That theory is constitutionally illiterate. Justices do not owe presidents anything except their honest, independent judgment. The confirmation process creates a constitutional officer with a lifetime of security specifically to prevent this kind of transactional loyalty. And yet, there he was, on screen, accusing them of sabotage, calling them betrayers, and lamenting that his own tools had turned in his hand. The meltdown is so damaging precisely because it is unfiltered. It's not a poll-tested talking point. It's the raw, unvarnished shock of a man who genuinely believed the institutional investment would yield institutional protection, only to discover that the institution protects the law first. The betrayal he feels is not a betrayal of him. It is the system working exactly as the founders designed it, independent, principled, and utterly indifferent to the identity of the person standing in the dock. Let's dissect the anatomy of this constitutional earthquake piece by piece, because the shockwaves travel much further than the headlines suggest. First, there is the blank check doctrine. What the court did here is establish a hard ceiling on executive authority. The major questions doctrine is the hammer. It says that if the executive branch wants to claim power of vast economic and political significance, it needs to show a clear, explicit permission slip from Congress, not an inference, not a creative reading of a vague statute from the 1970s, a specific, unambiguous authorization. The court looked at the 50-year history of the International Emergency Economic Powers Act and noted that no president, not even during the height of the Cold War, had ever tried to stretch it this far to impose permanent sweeping tariffs. That 50-year history isn't trivia. It's constitutional evidence. It proves that the power was never understood to exist. If it had been there, someone would have used it. By ruling that this blank check doesn't cover permanent global tariffs, the court has essentially declared that the era of governing by emergency declaration has hit a constitutional wall. This travels across immigration, domestic security, and foreign policy coercion. If you want to act like a king, you need a very specific, very clear grant of power from the people's house. You can't just scribble it on a napkin labeled emergency. We must examine the Gorsuch and Barrett defection. This is the psychological knife in the back for Trump and the institutional victory for the country. These two justices are the living embodiment of Trump's first-term judicial legacy. Gorsuch was the prize for holding that seat open under McConnell's blockade. Barrett was the last-minute reinforcement rammed through against a backdrop of national chaos. They owe their robes, in a political sense, to him. And yet, they applied the same rigorous, textualist, conservative legal methodology that they were hired to apply, and they found Trump's argument lacking. This is the ultimate proof that the conservative legal movement is not a personality cult. It is a jurisprudential philosophy. And in the clash between philosophy and personality, philosophy won. This is a devastating blow to the morale of the executive branch because it signals that the Supreme Court will not serve as a rubber stamp for the unitary executive theory on steroids. The meltdown psychology. Why did he go on live television and scream? Because this wasn't just a policy loss. This was a humiliation of the ego. The "my own justices" line is the giveaway. It reveals that Trump views institutions as extensions of his personal will. The shock on his face, or rather the fury in his voice, was the shock of a man realizing that the levers of power are not actually wired directly to his fingertips. The political damage here is exponential. It makes him look weak precisely at the moment he needs to project maximum strength. It confirms to every Republican in a swing district that defending this president requires defending the premise that Supreme Court justices are traitors if they rule against him. That is an impossible position to defend at a town hall meeting. The collapse of the second-term strategy. The tariff authority wasn't just a tool in the toolbox, it was the toolbox itself. The entire plan for dealing with China, the European Union, and global competitors relied on the ability to unilaterally drop economic hammers without having to negotiate with Nancy Pelosi's successor or Chuck Schumer. That strategy is now in constitutional shambles. The administration can still use specific statutory tools like Section 232 for national security or Section 301 for unfair practices, but those have specific limits and processes. The ability to wake up, tweet tariffs, and move the global market by sheer willpower has been checked. And when you combine this with the ongoing Iran quagmire, where the military option is bogged down and the economic coercion option has just been kneecapped by the court, you see a strategic architecture that is collapsing under its own weight. The international credibility dimension. This is where the rubber meets the road in geopolitics. Foreign governments, from Beijing to Brussels, are not staffed by fools. They have legal attachés and trade ministers who read the Supreme Court opinions the moment they drop. They now know that the primary threat the Trump administration wielded, sweeping, indefinite, unilateral economic punishment, has been ruled illegal by the president's own hand-picked court. The threat of, "do what I say or I'll bankrupt you tomorrow," is now a paper tiger unless Congress gets on board. And given the current fractured state of Congress, that is a high bar. The leverage in every single trade negotiation and diplomatic standoff has just shifted. The President of the United States can rage about it on camera, but the foreign ministries of the world are adjusting their risk models accordingly. The credibility of American economic power as a personal weapon of the president has taken a direct hit from a 6-3 ruling. The political cascade. This ruling does not exist in a vacuum. It lands on top of a pile of other institutional grenades. There are impeachment articles circulating. There is a Senate that is no longer a reliable rubber stamp. There are state-level electoral swings that look like harbingers of a blue tsunami. And now, on top of all that, the Supreme Court has publicly clipped the president's wings. This creates a permission structure for Republicans to start distancing themselves. They don't have to come out and denounce him. They just have to say, well, the Supreme Court has spoken and we respect the rule of law. It gives them an off-ramp from the burning vehicle. The accumulation of these institutional rebukes is building a pressure system that is reshaping the political landscape for the upcoming election cycle. The reign of the emergency power autocrat is over. The united stand of the justices drew the line. And the meltdown on live television served as the confirmation hearing for the fact that the man who built his brand on being an unstoppable force has just discovered that the Constitution is an immovable object. Let's bring this home with absolute clarity. Point 1. The calendar is still ticking, but the theory is dead. The ruling ends the constitutional justification for governing by emergency decree. The blank check is void. The administration now has to work for a living, legislatively speaking. Point 2. The united stand of Gorsuch and Barrett proves the independence of the judiciary. This is the constitutional immune system fighting back against a perceived infection of executive overreach. It is the most significant repudiation of the "my justices" mentality possible. Point 3. The meltdown matters because it shows the world that the president was genuinely surprised by this. He built his house on the sand of personal loyalty and was shocked when the tide of legal principle came in. That surprise is a strategic vulnerability. Point 4. The political cascade is now unavoidable. When you strip away the economic superpower, you strip away the fear factor that kept many Republicans in line. The walls are not just closing in because of political opponents. They are being reinforced by the very institutions he claimed to own. This is the story of how a 6-3 ruling, authored by a coalition that included the president's own appointees, drew a bright red line around the office of the presidency. It is the story of how the myth of unlimited power met the reality of limited government. And it is the story of a man who, upon discovering that his fortress had a back door he didn't control, chose to scream at the guards rather than read the architectural plans. The reign of the blank check has ended. The united stand has spoken. And the meltdown was simply the audio track playing over the closing credits of this particular chapter of the constitutional crisis. If you understand now why this is bigger than tariffs, why this is about the very definition of the office, make sure you're subscribed because the aftershocks of this ruling are going to define everything that happens next. We'll see you in the next one.